do anything with it.
It's not going now. I can. You guys should start now.
I would start before you leave. Is the microphone on?
Microphone's on.
Microphone's on? We're
Oh,
live.
live.
Okay.
Interwebs.
Interwebs.
There we go.
Okay. All right. Good luck. I hope we give you good medicine. Good medicine.
Let me get you one.
I think, yeah.
Wasn't sure if somebody.
They may have drank both of them. I don't know. There's a chance. You drank both these glasses?
So I've been drinking out of that one.
Oh, okay.
I don't know what Jim's plate is. The other one.
Jim's plate or Jim's plate. All right. Good luck.
Pass it around.
Hope they give you good medicine.
Yes. Yeah, this should be good.
No, that's good. I'll keep an eye on it. I'll come sit because I got to charge my computer anyway. So.
See it.
Are you all done with your coffee?
I know, it's great.
Did you see Sarah that?
I just,
Oh, it's
just
fine.
black out screen.
Okay.
I wonder. I was like,
I thought that'd be a great constitutional challenge.
Obviously.
I like it,
but it's an
Okay.
Black.
But it's not sleeping, it's just that out. Black. Blacked out. Okay. Okay, good luck, honey.
Even
Even
legislative
then.
council was confused apparently. So
Absolutely.
Very, I'm curious as to what actual bill he signed. I'd love to get a copy of the actual signed bill to see what it looks like. Because this may in fact not be the law. Possible. The governor signed a bill that was entitled something else, so I don't
Yeah,
know.
well, that's why we pay her because
I think it's interesting.
my eyes roll back in my head. I'm like,
Yeah.
I know, why are we all here? I don't know.
Oh,
All right, I think these last two. So we're going to get started. I'd like to introduce Caroline Earl. She is a local attorney and the attorney we use at LifeMap, and she's going to talk to us more about Act 35 today.
Good morning. Good morning. So as Sarah's mentioned, my name is Caroline Earl. I'm an attorney who's practiced in Vermont for the last 24 years, and I'm going to attempt to use my courtroom voice here today. So if there's any problem hearing me, please let me know in the back. I'd be happy to put on the microphone. So just briefly, my experience in the mental health area. I was with the Attorney General's office for about 8 or 10 years. I was the chief of the Civil Litigation Division during some of that time. And so during that time, we represented, of course, the Department of Mental Health, the Commissioner of Mental Health, as well as many other folks in the mental health department. I have defended nurses and those folks who worked at the Vermont Psychiatric Hospital at that time with civil suits. We generally did defense on behalf of the state of Vermont. So we defended lawsuits and challenges to the constitutionality of laws, et cetera. So in that capacity as an assistant attorney general and then chief of the civil division, I dealt with pretty much every person in state government in the mental health community, and frankly, in every aspect of the state of Vermont community, from the plow truck driver up to the secretaries of the agencies and the governor. So I have a fair amount of experience both with the Department of Mental Health and other agencies in state government. As Commissioner of Human Resources, I also went to the legislature quite often in order to represent the administration on behalf of particular initiatives or when they had questions about human resources. So I did that for a couple of years as well, and so have some pretty good knowledge of the legislative process, which was useful, I think, in analyzing where the heck this law came from and what it means or what it might mean for you folks. I also, in private practice, I've been in private practice for the last 7 years in my own firm, which is right across the street on the second floor of the old Thrush Tavern building. And in that capacity, I've represented the Commissioner of Mental Health on a number of occasions when they have had conflicts within their own agency. Those particular instances have included when they've had an individual who the Commissioner of Mental Health has wanted to change location. Someone, for example, at the Brattleboro Retreat, who they have found no longer needs treatment per se, mental health treatment, but is in a status quo situation, and they want to relocate them to a secure facility. And the state's attorney has objected in some of those instances. So I've represented the commissioner in his or her capacity trying to get those transfers made. So I've represented the department both in and outside of state government. I also represent mental health care providers. And so in that capacity, I will tell you, I'm not a school attorney. So I know some of you are affiliated, many of you with schools. I'm not a school attorney, and I'm not here holding myself out as a school attorney. My colleague, Robin Freeman, who will present to you this afternoon, has experience working with schools, and he will provide, I think, much more of a school perspective on this. But I did want to kind of mention that disclaimer right off the bat. So I got involved in this because I had Sarah White actually approach me, and she sent me an email back in January, at the beginning of this year, and asked, she said, you know, there's this Act 35, this statute that we've all of a sudden become aware of. We have no idea where it came from. We have no idea what it means. Could you please look into it and see if you can discern what this is all about and where it came from? Because Sarah's, I gather, pretty tapped into the mental health community and what's going on up there, and she had not heard of it. And so the concern was, who else has not heard of it? And so at that point, I contacted the Department of Mental Health. I asked them what this was all about. I took a look at the one, you know, basically it's one provision in the law, so it's a paragraph essentially. I took a look at that and I called the Department of Mental Health and said, you know, what's going on? Where did this come from? Did the Department of Mental Health have any input into this? And it was very curious. The response I got back, first of all, there was a delayed response. They didn't get back to me right away. Then the response I got was, we really don't have much knowledge of this, and we were not part, they said we were not involved in the passage of this legislation. They agreed that the language was quite broad. So that raised our antennae a little bit, I think. And we pursued that a little further. And as a result of our questions, the Department of Mental Health, the commissioner, ended up requesting a memo from the two chairs of the Senate and House legislative committees that were responsible for considering and passing this law out of committee into the general body. And there was a memo then that was issued in probably mid-January of this year that spoke to their intention behind this act. And I believe that you have a copy of that memo in your materials. Again, it's just a couple paragraphs, and it speaks to the intention that this committee had, which is quite interesting because, in fact, when I did the legislative history research, which I did later for purposes of preparing for this seminar, in fact, the stated intention of the committee went awry, I think, a little bit, based on what they're telling us. Most recently, I had been told, because we had circled back to the Department of Mental Health and asked them if they intended to pursue clarifying language, some kind of language that would actually make the intention of this bill obvious and evident, and address the kinds of issues that I think we're going to talk about this morning, issues of potential liability, potential compliance, informed consent, those kinds of issues. I was told by the Department of Mental Health General Counsel, Karen Barber, that she believed that the legislature would be taking up a curative act this session. I circled back to her this week, and she said that the legislature has not done so, and she said that the Department of Mental Health has not pursued any amendment to the act. So at this point, it appears that despite concerns that have been raised by the mental health community, the legislature apparently is happy with status quo. They don't perceive, at least at this point, any need for a remedial act or some sort of remediation of that original act. And so that's where it stands now. I think at the end of this day, one question that you folks want to consider, because you are in the boiling point here of this act, is whether or not you folks want to mobilize in some way, whether that's a grassroots effort, whether you have a lobbyist. I don't know if you have representation at the State House that you have retained, but I think you want to consider whether or not you want to put forward to your representatives some sort of clarification or proposal to clarify this act. So keep that in the back of your mind as we talk today, whether or not that is worth considering and worth pursuing. So let me start by the actual language of the provision itself. So this was passed out as H230, House 230. It was proposed in the House, and it was enacted last session, effective January 1st of this year. And the language, as you see, which I think you have a copy of in your packet as well, a minor may give consent. Well, let me start by saying that the title of this act is important. Consent by minors for mental health treatment. That'll come into play later on when we talk about legislative history. But again, this is consent by minors for mental health treatment of any kind, right? That appears to be the case under this broad act. A minor may give consent to receive any legally authorized outpatient treatment from a mental health professional, as defined in Section 7101 of this title. Consent under this section shall not be subject to disaffirmance due to minority of the person consenting. The consent of a parent or legal guardian shall not be necessary to authorize outpatient treatment. As used in this section, outpatient treatment means psychotherapy and other counseling services that are supportive but not prescription drugs. So again, the questions obviously that immediately arise are what? I mean, what questions immediately arise in your minds as mental health practitioners, as school folks who are involved in these types of cases? What concerns do we have right now, just looking at that as written?
Can a 6-year-old student really give consent?
Right, age of consent. So what is the age of consent? About 36 other states in this country have mental health consent laws allowing minors to consent to treatment. The vast majority of those begin the age of consent around 13 or 14. So those legislatures have made a decision to sort of hold back kind of the tide, this general broad definition. They thought about what age an individual can actually form the kind of consent, the meaningful consent that you folks are used to dealing with every day. And they've decided in the vast majority that starts at around age 13 or 14. In New Jersey, the law begins at age 16. So there are 2 years in New Jersey, the ages of 16 and 17, that a minor can consent to medical treatment or mental health treatment without the consent of a parent or guardian. So that's exactly right. So what other issues are raised by this from your perspectives as practitioners and interested persons?
I just have a clarifying question.
Sure.
Act 35, is that just in Vermont, or every
Yes.
state has different? So that's
Exactly. So we are talking about a Vermont statute that was passed by the Vermont legislature.
Okay.
This is very much a state issue. So every state has the opportunity to determine the kind of mental health parameters and laws that they put in place in their state. So that's a good clarifying question. Yes. So any other issues raised by this general language that we see here? What about the issue of medical records? So if I'm a minor and I decide I want to receive mental health treatment, I am, for whatever reason, intimidated or not inclined to go to my parent or my guardian and seek authorization or permission to do that, and I go to you as a mental health practitioner and ask you to give me treatment. Maybe I'm 14. You talk it through with me. You decide that I do have the capacity to consent to mental health treatment. You talk about the parameters of that treatment, and we begin treatment. And then my mother calls 2 days later, and she asks for the medical records, the mental health treatment records that you have created arising from my treatment. What about that? Is that addressed in this law? I don't think it is. I don't think it is. Now, my colleague Robin Freeman will talk to you about that in the context of HIPAA this afternoon. But that's a big question that is out there, right? Let's take another question, because I've been an attorney in the state for 24 years. I've read thousands of Vermont law cases and other jurisdiction cases. There are cases in which mental health treaters, providers, have been sued by patients arising from some sort of treatment. Is it possible that a parent could sue a provider in the event that they proceed and give treatment to a minor under this provision, but then something happens with respect to that minor? There is some incident that happens, potentially self-harm or something else that happens. Could a parent then bring a lawsuit against that treatment provider? What would your defenses be? Do you have defenses? Those are big question marks from my perspective. I certainly would defend a mental health practitioner in that case, and I think we'd have some reasonable defenses, but it's putting you, I think, in a tough position. So the liability issue, the HIPAA issue, medical records issue, the informed consent issue, these are three big issues that I see that derive from this general language that we're talking about. So those are things to consider, and we'll talk about those, as well as this afternoon, my colleague, as I said, Robin Freeman, will talk about those. So let's talk about what this means, Act 35. And there are some clues. We have some clues as to what this means, okay? And the first clue, from my perspective, was the memo that we received from Senator Claire Ayer and Representative Bill Lippert, the chairs of the Committee on Health and Welfare and the Committee on Health Care in the House and Senate, respectively. This memo was issued January 6, 2018. I think you have a copy of it I hope you do, in your materials. What they tell us is that it was their intent to create access to treatment for children and adolescents who may not otherwise seek care, in recognition that expanded access may be life-saving in some cases. It does not require, according to them, this act, mental health providers to treat minors, nor does it prohibit mental health providers from seeking parental consent. So that's a big key right there, okay? So this doesn't compel any mental health provider, right, to provide treatment without parental consent to a minor. However, I would question this. If I am a minor and I go to you as a mental health practitioner and I seek treatment from you, and you deny me that treatment without the consent of a parent, would I, the minor, then have standing to potentially bring some action against you for violating this law, right? Because, you know, the law is all good and dandy, but if no one will treat me, no one will bring fruit to that law, then what is the good of the law protecting my right to seek mental health treatment? So there's a catch-22 here, right? Practitioners on the one hand are being told by Senator Ayer and Representative Lippert, hey, no worries, you don't have to actually provide mental health treatment to any minor without consent of the parent if you don't want to. But on the other hand, you've got a law saying that these minors are entitled, really, right, to seek that treatment. So I think there's a contradiction there, and I think that makes it it puts you guys in a difficult jam. As always, these folks say, mental health providers are obligated to use clinical best practice, which includes seeking parental or custodial engagement when appropriate. Well, what the heck does that mean? So now you're being told you don't have to seek parental consent, but the memo from the folks who are responsible for enacting this law are saying, you know what, best practice indicates that you should seek parental and custodial engagement when appropriate. Again, leaving it up to you folks in this very, this shifting land right beneath you, leaving it up to you folks to figure out when that's appropriate. It's beginning, to my mind, to wonder sort of what's the real meaning of this law? What's the importance? What's the impact of this law if all of these loopholes are being provided, right? Act 35 does not require a clinician to accept a referral or to provide treatment to a minor without reimbursement. So guess what? You can ask for payment. It's not obligating you, good news, to provide your services for free. But on the other hand, unless you're in a school setting where perhaps this is incorporated into your environment and into your budget structure, you private practitioners or you folks who routinely bill for your services, again, how do you deal with that? My colleague Robin Freeman will have some ideas about that, or at least some insight into that this afternoon. But again, a big question for you. It doesn't compel you to provide free services. So how do you get paid when it's not the minor whose insurance generally you're relying on? Okay? And it finally says that their understanding is that current best practice requires that mental health providers make a clinical determination as to each prospective patient's capacity to provide informed consent to treatment. So we're leaving that up to your clinical best judgment as to whether or not the individual standing before you, the minor, is able to consent to that treatment. How comfortable are you folks with that determination? Is that a determination you make routinely in your practice every day? Do you guys deal with that issue every day in your practice? I mean, if you have to get parental consent generally, or a guardian's consent to provide treatment to a minor, do you ever grapple with the issue as to whether a minor can give informed consent? Are you experienced in that determination? Okay, not at all. So again, they're leaving it to your clinical and best practices when it sounds to me like routinely you may not actually exercise that sort of skill because it's not really required of you. So this is new territory for you folks. This is new and kind of scary territory. So that's kind of our first clue, which really doesn't lead us to, the treasure, in my opinion. I mean, it's a clue that's a little more confounding than it is helpful from my perspective. Any thoughts about that before we move on? This memo? So now legislative history. And this was an interesting journey. I went back and researched the legislative history, which you can do now much more easily online, which is great. And it brought me back to my social studies 8th grade class of how a bill becomes law. So that was kind of fun. So I went through this, and it was a fascinating journey. And you have those materials, I've been told, in your folder. And I want to go through these materials in some depth. And the reason for that is because this gives us insight as to how this came about, why it came about, and really what it might mean. So let me start you, and I'm sorry these pages aren't numbered, but I want to start with a memo that was provided by Representative Gabrielle Luck of Hartford to the Senate Committee on Health and Welfare on H230. It's one page, about maybe a quarter of the way into your packet. And what she tells us, and this will be interesting to the school folks among us, what she tells us is that in the fall of that year, that 2016 fall, she was approached by a constituent who is a school counselor. She asked why we allow minors to seek mental health services without parental consent for alcohol, drug, and sexually transmitted diseases, and not for sexual orientation and gender identity issues. So this started as a result of one constituent going to her representative and being concerned about the ability of a minor to give consent specifically related to mental health treatment regarding sexual orientation and gender issues. So that's important to keep in mind, because that was the originating point, and it was pretty much the intent of this law as it went through about 3/4 of its journey through the legislature. It was the last quarter of the journey in which it transformed to open up to be a general mental health consent law. She talks about the fact that she has experiences working in residential life and college health services, where she knows that these issues can be very devastating for young folks. If they don't have guidance, it can lead to suicidal potential ideations, self-harm. And she felt this was an opportunity for the Senate to expand the access to mental health services and treatment to minors. So she came across 30 states allowing minors to access this help without parental consent, and she asked for the committee to consider this legislation. She also asked eventually for them to consider it under amendment to broaden it. But that was where it began. It began with the concern that young people dealing with gender identity, sexual orientation issues were not comfortable going to parents for consent, and were not able to get the mental health treatment that they deserved and required, and therefore that put them at risk. So that's where this began, this journey. So the original bill, which is on the next page of these materials, spells out that original intent. It's H230, and it says bill as introduced. And you'll notice that the title of this bill is Consent by Minors for Mental Health Treatment Related to Sexual Orientation or Gender Identity. So it was specifically geared toward folks struggling with those issues and dealing with that particular challenge. So next, we got to a point where they took testimony. And if you look about halfway through your packet, you're going to see that there's actually a list of the witnesses who testified on behalf of this bill. And what I found kind of interesting with respect to this list, and it's about maybe a third of the way through, it says H230 Act 35, an act related to consent by minors for mental health treatment, and it says committee activity witnesses who testified. Now, what I found interesting in light of Sarah approaching me about this bill and questioning where the heck it came from, I thought it was interesting the limited number of witnesses who testified related to this bill. And I was curious, when you look over this list, and I don't know if you guys, do you have that in there? It looks like this, looks like that, H230. Again, it's about a third of the way through, I'd say. It's before the amended bill. But the House Committee on Healthcare, it took testimony from Mitch Barron, the director of Centerpoint Adolescent Treatment Services, Stephanie Chestnut, a school-based clinician, Darlene Fury, executive director of National Association of Social Workers, Vermont chapter, Representative Gabriel Luck, that's the representative who initially brought this to the House's attention as a sponsor, and Kate McClinn, legislative counsel for the Office of Legislative Counsel. That was in the House. In the Senate, it was a little more expanded. The Commissioner of Mental Health did testify regarding the bill. Dylan Burns, the Director of Mental Health Services for Vermont Care Partners. Darlene Fury, National Association of Social Workers. Sue Krakowski, MVP. Again, Gabriel Luck. Kate McClinn, again, Ledge Counsel. Nick Nichols, Policy Director of the Department of Mental Health. Jessica Oski, lobbyist, Neckerson Group. And then we had a doctor, an associate professor of psychiatry and pediatrics, as well as Ken Schatz, Commissioner, Department of Mental Health, and a parent. So again, from my perspective at least, having seen the legislative process over the years, I can tell you that this list is pretty scant. This is a pretty short list. And I'm curious, now that I've kind of shared this list with you, to what extent are you familiar with the folks who testified regarding this bill? To what extent do they comprehensively represent the mental health community, both in terms of school, the school setting as well as the private setting? Do you recognize these names? Are these people well known to you? Do they represent the mainstream of, or whatever, the general consensus of your community? Any recognition of these names?
Just a couple.
Sorry?
A
A couple? Okay.
Yeah.
Okay. Well, let's go through a little bit of that testimony. I did not, I will confess, listen to the 30 or 40 hours of testimony that was provided. I did look over the written submitted testimony. And there were some other things that were submitted that I'd like to share with you. One, about halfway through your packet, there are 2 surveys that were submitted to the legislators from Outright Vermont. And from what I can gather, this is an advocacy group on behalf of the transgender community. So they provided 2 surveys, which are heartbreaking, these surveys. I mean, they're heartbreaking because they show that as heartbreaking it is for any youth to experience suicidal ideation, bullying, physical abuse, etc., the LGBT transgender community appears to suffer those challenges at a much higher rate, as far as we can tell from these surveys. And so clearly the legislature looked at this, these kinds of submissions and said, this is a huge problem. We need to protect this group. This group is worthy of, really specific and identifiable protection. So, and if you look at the 2013 to 2015 survey, which is on the second page, and then if you turn back to the, to the 2015 survey, at least my quick perusal, it appeared to me that the numbers had only increased in terms of the adverse impacts, challenges, stressors that these kids face from year to year. So this is the kind of information that the legislature was getting. And of course, that is a group worthy of attention. They're worthy of protection. They're worthy of certainly of law that protects them. Whether or not the law that ended up being enacted is a law that will protect them is another matter, I think. But that's what the legislature was looking at. The next submission that I looked at, and it's in your packet, is by Mitchell Barron, who is apparently the executive director of an organization called Centerpoint. Is this well known to you folks, this organization?
Absolutely.
Oh, yes. Okay. And so I have to say, I thought his written testimony was persuasive. It was articulate. He's clearly a pretty smart guy. He talked about this primarily in the context of treatment. So he looked at it more, as far as I could tell, as, listen, we give certain types of treatment already to individuals without consent of the parents, and he took them through a little bit of that history and how that works. And that's what I sort of got from him. What he was, I think, testifying to in written form was the fact that there are ways to navigate the minor consent issue that doesn't put the clinician at risk. So he was talking about, again, just as the Representative Lippert and as Senator Ayer mentioned, he's talking about the fact that any therapeutic goal ultimately will be to integrate a parent or a guardian into the mental health equation, right, in a supportive way. If you need to start with a child, eventually the goal is to have the parent at least fill a supportive, capacity and role in that regard. So he talked about that, and he said that Act 230, from his perspective, had that same goal, to eventually incorporate and integrate the parent or guardian into that mental health treatment. So from his perspective, that made H230, he was reassured by that goal and that clinical imperative, and so he felt that H230 made sense. Now again, he was, as I understand it, he was really looking at this in the context of the H230 as of March 14th that still focused on a law intended to support the challenges of specifically those dealing with gender identity and sexual orientation. So he was not testifying as to general mental health minor consent. So then we move on to March 17th. And the plot thickens here. We have Rick Barnett, who is a PhD, it looks like a psychologist, or maybe a doctor, yeah, PhD psychologist, Dr. Rick Barnett. And do you folks know him? Is he well known to your community?
Yes.
Some of you? Okay. All right. And so he, again, his perspective, again, he's looking at this, he's providing written testimony, and if you see in the second sentence of his letter, related to the minor's sexual orientation or gender identity, his testimony is focused specifically on that. And he is, again, he feels that the bill is straightforward, it makes a lot of sense. He felt it created a place of trust and safety for minors. However, he did have some questions. So there was someone who raised, right, some of the questions, raised the red flag at some point that I think we still have concerns about. One of his questions, is there an age at which not define it, but I think he asked the right question. Number 2, are there other issues? And this is interesting because I think this began to be potentially the wedge through which this became a general consent law. Are there other issues facing minors that would encourage them to seek and utilize services offered by mental health professionals or institutions if similar provisions were made for those issues? So he's kind of the first clarion call, I think, here that said, hey, why are we focusing only on folks, young youth dealing with these challenges? Why don't all minors deserve the protections of our laws and deserve the opportunity to seek and receive mental health treatment without needing the consent of a parent or guardian? So that's interesting to me in terms of legislative history. Turning to the next The next written testimony, the Vermont Federation of Families for Children's Mental Health, April 11th, 2017. I'm presuming that this is a well-known organization among you folks? Is that right? Yeah? Okay. So she is the executive director, Kathleen Halsopple, and she also commented on H230 as it applies to parental consent of a minor of any age. Now, at this point, the legislative history is a little fuzzy, but it appeared that about mid-April is when the turning point came. At that point, the Senate proposed an amendment that would open this up to consent by minors for mental health treatment, any minor. So that's when it seemed like it became a bit broader. And so again, she did raise a red flag here. She said the age of the minor must be outlined or defined. And we suggest that adolescent ages 13 to majority be considered in this bill. We further suggest that some terms be defined, such as supportive counseling. So again, someone from your community raising a red flag that the age of consent needs to be defined further. The legislature did not answer that call. We then have on April 18th, really from our perspective, finally, the Commissioner of Mental Health weighing in, at least to the extent that they did. I did not listen to the Commissioner's oral testimony, but the memo that they sent to the committee, the Senate Health and Welfare Committee on H230 on April 18th said that that they really wanted this to be put on the back burner. They were saying, listen, there's too much uncertainty here. There's lack of clarity. There's concerns that we have. We want an opportunity to have all stakeholders involved, which would mean presumably you folks, right? As well as minor representatives, et cetera. We want an opportunity to look at this in a meaningful, mindful way, deliberatively, and get back to the committee by January 15th, 2018. As we know, that didn't happen, but the mental health commissioner, that was their sort of pitch. Apparently she wasn't persuasive, unfortunately. There was a feeling that this was a case of urgency, right? And that it needed to be acted on now. And so that's what happened. Which with all the more reason it strikes me as odd that the Commissioner of Mental Health now is not leading the call to clarify this bill, to define those terms. I'm not sure why now they have dropped that ball. It's a curious contradiction. I don't know. It'd be something you might want to ask your representatives, or you. Okay, I'm not sure who this is, but the policy director over in Watersong fully supported H230 and asked for it to be considered and in the full Senate. So it looks like they work against domestic and sexual violence, working with children and youth. So again, somebody who by the name, an attorney, by the name of, I think it's Jessica Oski. And I actually have never met Jessica Oski, so I was curious about this because she says she's an attorney in here, and I've never met her, and I've practiced in Vermont for 24 years, particularly in this area. And I looked her up, and she's actually an inactive attorney for Vermont. I don't know how long she's been inactive, but she is not an active attorney. And as far as I could tell from her testimony, she was really presenting this testimony as a parent of a 13-year-old child. So it seemed to me she was presenting this testimony as just an individual citizen of the state of Vermont. But she talked about some issues here. She talked about the federal law. She talked about HIPAA a little bit. She talked about the fact that 35 other states allow outpatient mental health services to minors without the consent of a guardian. She did talk about, to some extent, the LGBTQ community. She talked about age, a little bit. And her position was, according to the legislature, that, you know what, we're all good. This is good enough. The way that these issues have been dealt with for purposes of, aid counseling regarding AIDS or counseling regarding, substance abuse, the way those issues have been dealt with, which allows, as I understand it, Vermont practitioners to see minors in those circumstances without parental consent or guardian consent. She said the fact that this has happened in those contexts suggests that we'll be fine with a general law allowing mental health practitioners to provide informed consent by minors. And I guess I wanted to open that up to discussion by you folks. You're the ones who are experienced in this. I'm presuming, I didn't research the law on this, but my understanding is that is true, that a minor can seek counseling on certain issues related to abuse or substance abuse or things like that without a parental consent or guardian consent. Is that right? So how does that work? I mean, how are you, as a practical matter, is that done in the context of a organization that doesn't charge an individual for those help services? Is it done in the context of a school where there wouldn't be an individual, payer-provider model? How does that work right now? And how do you deal with the issue of consent right now in those circumstances? Does anyone have experience with that, direct experience?
I think for us, it happens in school, right?
Okay.
Where there's no, it's, the provider's paid for.
Okay.
So there's no issue to having to have a parent pay for it.
So you have, for example, a guidance counselor might talk to a student about these issues? Is that the
A
context?
school counselor,
school
social worker,
counselor,
or a SAP.
Okay. And in that context then, let's say I'm a parent and I call you up and I say, hey, my son Nathaniel has talked to a counselor there, and I'm real life example, by the way, my son Nathaniel is alive. And I call up and say, hey, my son Nathaniel's been talking to a counselor. I'm kind of curious what they've been talking about. How would you, I'd like the records. How would you respond to that?
So I would say not a lot is written.
Okay.
And they're provided confidentiality unless they're going to hurt themselves or somebody else.
Okay.
So I would say to you that that we've been chatting about things and that the relationship seems to be going great.
Okay.
And I highly encourage you to talk to Nathaniel.
Well, I can tell you as someone who has dealt with mental health experts in litigation and, et cetera, I am always amazed at how little you folks can put in your notes. It's extremely impressive, and yet you remember apparently each particular patient and what's going on with them. I don't know how you do it. You just have photographic memories or something. But so I'm not as concerned, honestly, from my perspective, given my experience with clinician notes, that somebody's really going to be able to decipher these things, a parent, and figure them out. But I am curious about that. So what about so you're saying that you can just say, you would give the response you would give. What about if you're a private practitioner and you're dealing with a youth in that situation? Do you give the same response as Lisa, that this is private, and unless Nathaniel's at a risk of harming himself or someone else, I can't divulge those notes to you? Talk to your son or daughter about it.
Well, to a parent, that's our general approach towards anyone's.
Okay.
I've
Even if a parent has given consent to the treatment, for example, that would be your general approach?
yes, if a parent
Okay.
has given consent, then
Okay.
And that is a part of the informed consent process currently.
Okay.
And when I meet with a parent and a child, the parent understands the limits, the
Okay.
extent of confidentiality. And I follow more kind of the ethics of my license with that.
Okay.
So like I'm not a certified alcohol counselor, so I don't follow the ethics of the law that way.
Mm-hmm.
And it's very limited, so I don't have a lot of experience with like working with a kid without parental consent.
So what you're saying is you define the parameters of that consent at the
Yeah.
beginning of the relationship to allow you to afford those protections
Right.
to your particular client or your patient.
And in my experience, I've had parents withdraw consent and then it stops cold.
Okay. Meaning the session, meaning the,
Yeah.
You can't
I don't have
continue.
consent.
okay,
I work in a school.
Okay.
I'm a school employee in a school.
okay.
And that's.
Does anyone else, that's interesting. So, and I think that's meaningful, and I think that's something we'll talk about at the end and also this afternoon is, setting the parameters at the beginning, regardless of the context of the informed consent, I think is critical and is going to be critical under this law for you folks. And whether that's done by general education and health courses, whether that's done at the beginning of an actual, I think it should be done in a number of situations and a number of benchmarks, but one might be general education, one might be if it's done at the beginning of the clinician, relationship with the patient. I think there are various areas where you folks can kind of set those parameters, and despite this law and the uncertainty surrounding this law, I think you can afford yourself some protections, which are good. And it sounds like to some extent you're doing that already. So maybe the legislature was wiser than I thought. Maybe the legislature is seeing that you folks have kind of established these working clinician best practices already, and they can work for you. Any other thoughts about that? How you would deal with those situations if they would arise, where a parent would demand copies of the notes in this particular situation of a substance abuse or, yeah.
I think one of the keys, and this has become key for our practice is that we don't regularly have situations like that come up. So we can define that, and then 18 months into the relationship of counseling with a student, the parents get divorced. And now there's something ugly happening, and mom now wants copies of the records.
Right.
So depending on the age of that student, if they are substance abuse specific, that is a different release law. And so sometimes as counselors, we have to then dissect the notes and withhold substance abuse records while giving the other records. But the parent could still go through a legal process to trump that relationship and somewhat weak laws and demand those records as the parent who can then give the release for that.
And I will tell you, I think it's going to be very interesting to see how this law evolves and whether or not there ultimately are some legal challenges that come down the pike because of exactly the types of issues you're raising. I wondered, circling back to you, Lisa, are you, if Nathaniel went and availed himself, or Joe Smith went and availed himself of a counselor at school, are you required to inform the patient that that counseling relationship has begun? If Nathaniel doesn't talk to me about it, are you obligated to inform the parents?
No.
Okay, so that's an interesting question too from my perspective, right? Presumably under this law, part of the protection afforded the minor is they're not required to divulge the fact that that relationship has begun. And so that, to me, that's very interesting. And to me, again, I find that, what if, for example, and again, payment issues are a whole separate issue, right? But let's say for whatever reason this kid has the resources or something happens that they could trigger payment, whether it's the facility. Chris and says, maybe you've been giving treatment to a minor under this law. I want to know if so-and-so is receiving treatment from you. What do you say?
Well, that's a great question, because if it were anyone else, we'd have to have a release for information. Otherwise, we couldn't even divulge whether or not we heard that name before.
Exactly, and I think that's still well, and that's, again, I think, and that's a question, right? Presumably, if the child has the capacity to give informed consent for purposes of mental health treatment, they have the capacity to sign a release to disclose to anyone they like the fact of the therapy and maybe even the content or whatever of the therapy. But again, that's right. That would be another layer of protection for the child and another question that's raised.
And does that come into conflict with parental rights to medical records?
Exactly. This law clearly is in derogation of parental rights, right? This is limiting parental rights. So, but we have all these other laws that define parental rights. And so where does that end? And particularly in the cases of divorce or other things, where are those conflicts? How are those going to shake out? Those are big issues. But I do think that you should have feel some assurance that at least you have some level of experience in some of these issues relating to these other areas of treatment that are being provided currently to minors without the consent of the parent or guardian. And I would urge you, if you are not a clinician who operates within that context for whatever reason, I would avail yourself of the experience of your colleagues, use them as a resource in terms of trying to understand how they deal with these issues as they go along. Because I think there are comparables there.
Is there any precedent in Vermont law of parents suing any of these other healthcare providers for children seeking maybe medical attention without their permission?
I haven't done a review of the law in that area, Chris, I'll be honest. So I can't answer that question right off. The cases that I've encountered in my own practice have been cases involving mental health practitioners and issues involving access or particular clinician relationships, and whether there's been whether the clinician is liable for either actions or inactions taken in the context of either the patient themselves or a third party, depending on what's been going on. So I don't know the answer right offhand to that question. What I always tell people is, I deal with clients all the time who come in and they want me to sort of limit their potential liability and the scope of any vulnerability they may have to lawsuits. And when I finish doing whatever I'm doing for them and they get it and they say, okay, so I won't get sued, right? And I said, oh, well, that's a whole other matter. I can't guarantee anybody won't sue somebody. You could sue, anybody can sue somebody, right? The question is whether the suit has validity and whether it'll go the distance. So I guess I would say that I don't have experience reviewing that area of law. Having said that, anybody can sue anybody.
Right. It would be interesting to know the findings of those cases.
It would. So the last piece that I wanted to sort of just the legislative history that I want to share with you was something that was received again by the Legislative Committee in the Senate. And it was an article, a newspaper article submitted, I believe, by Jessica attached to her testimony. And that was an article regarding the New Jersey law that was passed last year or 2 years ago. And it sort of surveyed the process by which this proposal became law. And this was a young man who requested his parents' consent to receive mental health treatment, and she denied it. And so he worked within his Boys and Girls Club and other Boys and Girls Clubs in New Jersey in order to propose a bill and get it through the legislature. Interestingly, their bill, as was approved by both the House and Senate of the legislature in New Jersey, provided consent from the age of 13 on, the ability for informed consent by the minor. Governor Christie refused to sign that law. He said that he'd only accept it if they modified the bill for age of consent to be 16. So, so right now in New Jersey, kids 16 and up, 16 and 17 basically, prior to turning age of majority, can provide consent without parental consent and guardianship consent for mental health treatment. So I thought that was kind of interesting. So there, sort of in a nutshell, is kind of a little bit of the journey. And again, I haven't summarized the testimony for you because frankly I didn't listen to the 40 hours or so of tape. But that in a nutshell is kind of the journey that these took. And again, I was sort of struck by a few things. Number one, the fact that there was so much reliance made on these other areas in which minors can consent to treatment without parental consent or guardian consent. Whether that reliance is well placed or not as a model for you folks, I don't know, but I think there was a lot of reliance on that. I think there was a lot of reliance by the legislature that this was a critical issue, an urgent issue that needed to be dealt with now, because the statistics were absolutely, I think from their perspective, shocking in terms of particularly this, LGBT community, and they were concerned that this particular group was vulnerable. Now, what I found again fascinating, just as the final indignity of this law, from my perspective, was that in the first page of your materials, legislative history materials, you'll see the Journal of the Senate. And the Journal of the Senate is where they announce that the governor has signed certain bills. And so on Thursday, May 18th, 2017, a message was received from the House of Representatives by Ms. Rebecca Silbernagel, its second assistant clerk, as follows. Mr. President, I am directed to inform the Senate that the governor has informed the House that on May 17th, 2017, he approved and signed bills originating in the House of the following title. And if you scan down, you will see H230, an act relating to consent by minors for mental health treatment related to sexual orientation and gender identity. So the governor apparently signed the wrong bill. So I even question whether this is law, honestly. I find this an incredible oversight. And I really think it'd be fascinating, as I told Sarah, to actually go to the State House, find the original bill that the governor signed, make a public records request, and see whether in fact he signed the bill that's currently law, because the title is incorrect. So I find that, I mean, again, that kind of blows my mind. But again, I think it shows sort of that the overarching intent of this bill was designed to focus on a particular community. At the last minute, relatively speaking, its legislative journey, it was opened up to impact all minors with respect to any type of mental health treatment. But apparently the original idea was still deeply ingrained, because that's apparently the bill that the governor signed. So future clarity, as I mentioned, the Department of Mental Health has indicated that a cleanup bill was to be contemplated in this session. It has failed to propose one. The legislature has failed to do that. I also, as I mentioned, I think that you want to consider whether your community needs to act at this point. That will be for you to decide, maybe after today's session, or maybe after contemplating this a little more. It was my understanding that your community, and maybe that's through certain organizations, had a governmental relations specialist or lobbyist who is representing you folks at the State House. I'm certainly sure that you guys from the schools have folks who represent you up there. And my understanding was there was a mental health community organization, a private organization that had that representation. If that's the case, I would go back to your lobbyists and I would ask for a refund. Okay, because apparently the fact that so many of you do not know about this bill suggests to me that your lobbyist was asleep at the switch. So, I mean, there's no way, if you're a governmental relations specialist, and I was married to one for 12 years, I mean, you're up there every day from 7 a.m. in the morning until 7 p.m. at night. You've got to know what's going on. And this was not a case where this bill was tacked on to another bill at the end of the session, like with 2 weeks to go. This was a 4-month process. So somebody should have known this was happening, and somebody should have asked for a wider stakeholder, I think, input. particularly from your own representatives. So, okay, you may not want to frame it that combatively as I did, but go back to your, but in all seriousness, go back to your representatives and talk about it. I think you should go back to the folks who are up there and say, hey, were you aware of this? You know, let's talk about how we can make sure that we're brought in on these types of bills in the future if they arise, because they're important. There is no one, as far as I can tell, in any of the history that's addressed liability whatsoever for clinicians in your shoes, depending on how this is interpreted and applied in the future. And that's a huge issue for you. Your work is hard enough without exposing yourself to unnecessary liability. So I think that was, yes, that's my last slide. So, and I'm not sure what time we're at or where we are.
It's 11:20.
Okay. So, you know, any other questions? I mean, any other points of discussion that you folks want to have about this? Again, yeah.
So I understand that there's other states that have a similar law, but with some kind of age restriction. Are there any other states that you know of that don't have that age restriction, or is Vermont making new ground?
I'm not aware of a state that doesn't have an age restriction right now. Vermont prides itself often on being the, you know, the newcomer, so the cutting edge. I can't say that for certain. I'd have to do a complete thorough, but my overarching sort of review suggests to me that all of the other states have some sort of age restriction. And I mean, is there a consensus in this room as to what that, would you have accepted? There were the two folks who testified by written testimony that I think they both proposed an age of 13, was my recollection. Do you folks have any sense in your community, in the little micro community we have here right now? What is your sense as to what the age of consent should be? Can a 6-year-old consent in a meaningful way to receive mental health treatment without parental guidance or input? So when does that age begin? And particularly when you're talking about sexual orientation and gender identity, at least the folks that I know who have dealt with those issues, and the folks I know who have grappled with those issues themselves personally, it's my understanding that you have a clue about those things pretty darn early on in your development. I mean, I know of someone who told me that he had a clue when he was like 3, 4, 5 years old. So at that point, if you're grappling with that, shouldn't you be able to get mental health treatment related to that? I mean, don't we want to get these folks, sort of get them in and processing these issues, these confusing issues as early as possible? I mean, isn't that best clinical practice? So does that inform the question of what age of consent should be permitted? Should this law have been limited to the LGBT community? Do you think that it would have made more sense from your perspective as a mental health community if it had been, as originally framed, simply limited to sexual identity and sexual orientation and gender identity? Would that have been a better use of the legislature's time? Any thoughts about that?
I think they would have had to just keep making more little, like, okay, and then this, like the drug and alcohol, you know, has a lower age. And so then if they did that, and then it's like they'd have to keep making little, and then this, and then this, and then this.
But you raise a good point, which is, and I don't know the answer to this, what is the age for, what is the age of consent for the treatment that we talked about earlier, the treatment that is on the books or had been on the books previously? It's 14? Okay, so at 14 years old, they can, okay. So do you think that the 14 age of consent is a good age for this? I mean, would that have been the better choice?
I think I would definitely have to have more discussion on that.
Mm-hmm.
And a lot, it's hard because it depends on the child. I mean, some people are, I have a 9-year-old who came in and I said, well, why are you here in therapy? And he goes, well, I have a lot going on in my life. I needed to come see a therapist. And I'm like, alrighty then. I'm really glad that the adult in your life listened to you and brought you in. I mean, he was absolutely sure at 9 years old he needed therapy, and he really appreciates that he has somewhere to talk.
Yeah.
Then I have other 9-year-olds that are like, hey, what game can we play? I mean, they're just, not there. So that's all kids are different as well.
One of the things I think is interesting is that from a mental health clinician's perspective, related to their identity and sexual orientation, whether there was really no, from what I could tell, no effort to understand how those might differ from someone, for example, who abuses drugs or abuses alcohol. And I don't know, I don't know if those are different, those come from different places from your perspective as clinicians. But again, anecdotally, what I hear is that gender identity issues can start from a very young age. Most, 4-year-olds aren't, taking crack. So, I mean, I don't, they don't have, you haven't yet reached those issues generally. So it's interesting to me that there seems to be a different age at which some of those things may come to light and may begin to provide challenges to an individual, a minor, as opposed to others. And there seemed to be no sense of kind of looking individually at those particular folks, how that evolves from a mental health perspective, and whether or not, therefore, that should impact the informed, the age of consent, and how that should impact the age of consent. Any thoughts about that? I mean, do you folks deal with, is this room, do you deal with folks who have gender identity and sexual orientation challenges and issues? Okay. So are you seeing that those evolve from a very young age, or are those more things that are come about in adolescence? Is there any way to sort of characterize that or generalize?
No, it's case by case.
Case by case. And so from your perspective, dealing with individuals in those situations and being a clinician or a counselor?
School counselor.
Okay. What would the age of consent be from your perspective? I mean, do you have a sense as to, for that particular issue, gender identity, sexual orientation, is the age of consent warranted to be younger than 14?
I would definitely want the support of having an identified age, not by my decision, but by a consensus of everybody and legally. However, this law is way too gray for anybody to make that decision. And even though I would not want that responsibility to say case by case, well, this kid's really with it and can, whether it's 13, whether it's 6, whether it's, not without a parental consent at this point. That's my point of view. I would rather that the law or somebody else dictate so that I would have that support. It's not something that I would feel I should make that decision on.
So in the context, are you in a school setting that is a elementary, middle school, high school, all of them?
So it's middle school,
Okay.
grades 6, 7, and 8.
Okay, so in your context, you are effectively then providing counseling on these issues without parental consent already, aren't you? If what Lisa says is true, that they can.
There is a difference in that as well.
Okay.
Because I'm a school counselor, my responsibilities and my tasks could be very different from the school down the street. So for me, because of our higher needs, higher risk students,
Yeah.
I play a different role. And there's a lot of, some might be more academically, do you know what I'm saying? Some might be more academically task-oriented and responsibilities.
Yeah.
Mine tends to be a little bit different, and I don't know how the high school, how that would play out. Mine tends to be a little more different, where I have a number of assessments for suicidality, self-harm. I have a number of, reports to DCF because there's domestic violence, there's neglect and abuse in the family.
But if you have a case where you've done an assessment and the let's say the risk of self-harm or the confusion is stemming from this issue of sexual identity, gender identity or sexual orientation, is that something you alert the parents about? Do you keep that? Do you encourage the child to go into counseling at that point?
At this point, I would always alert the adult, only because in any situation, your breaches are always around safety issues, and that will break confidentiality. So at that point, I'd rather go into court and argue the point that I let a parent know, rather than argue a point that I did not let a parent know of a minor. That's my thoughts.
What about others? There's other school folks in the room. What about others in that situation? I mean, do you currently have situations where you have provided counseling to individuals who are grappling with these issues? And has the general school confidentiality protected you? Has that created a bubble around you? And for purposes of providing consent, providing counseling or mental health treatment without the need for parental consent or the guardian consent?
I think there's a bit of a distinction between counseling and mental health treatment.
Okay.
From a school
Okay, that's
counselor's
fair.
perspective.
Okay.
We're not,
Are you licensed mental health counselors?
well, it
I
depends on the
am,
person.
but that's
Okay,
not my
okay.
capacity.
But our licensure does not require that you're a licensed mental health counselor.
Okay, gotcha. Okay.
So, and we're not, a school counselor isn't there to do therapy.
Okay.
We're there to be school counselors.
Gotcha.
So there is a distinction in that. We might do some crisis work and then make referrals, but our responsibility is to be a therapist.
Now,
So
when you
that's
make
the
those-
distinction between
It's brief counseling, it's 6 or 8 weeks.
When you make those referrals, let's say a situation like that, maybe it has arisen in your experience, maybe it hasn't, but let's say it does.
Yeah.
When you make those referrals, is that a referral you give to the parent, that you give to the child?
Yeah.
The parent. And
And
would you
that's-
still give it
that's
to
where
the,
this law gets very gray.
okay, from your
because we're-
perspective, it's the
yeah.
referral practice that you're talking about.
Yeah, I mean, and also, so if that's refused, so if we make a referral.
Yeah.
Up until January, if we made a referral and the parent refused to follow through on that referral or refused whatever that recommendation was, it pretty much ends there. You know, we can still meet with those students. We're a public school, it's a public service as part of the school, but again, it's brief counseling, it's not therapy. But this changes that potentially.
I think you're right. I think it does change it potentially. And I guess, you know, I'm curious, you know, I think you mentioned, I don't know your name, I'm sorry.
Sandra.
Oh, Sandra, and then Bruce. So Bruce mentioned that, you know, at the beginning of the therapeutic relationship, you kind of have this, you know, I gather this sort of informed consent document or something that you, publishing this law, publishing this potential point of access for minors in a more holistic way to the entire school community. So for example, I mentioned, I know there's, I forget the name of the course, Lisa, but there's a course that just, like a health course, let's say, okay? Most high schools, certainly, I'll talk about high schools right now, have health courses in which you talk about all sorts of things, right? Would this, have your curriculums at all, have you considered adapting your curriculum to include raising awareness of this type of right now that a minor does have to consent to this mental health treatment without a parental consent or guardian consent? Might that be a way to raise it in a more neutral context, educate the minor so that it's really the minor empowering themselves to seek the treatment rather than a particular clinician or a counselor or someone, at that point of initial contact, talking about that. From my perspective, the value of this law seems to me to be in the minor initiating the contact themselves and being aware that they can initiate that contact. If I'm going to a mental health practitioner, private or in school counselor situation, I'm reaching out to you. At that point, I really don't know what my rights are, right? I'm just a kid reaching out to you because I feel like I'm in trouble or I feel I need some intervention and I don't know what my rights are. Might it be better? And I might not reach out to you because I'm scared that you'll tell my mom, right? So, right? I got to believe that's where a lot of this comes from, correct? Over all of it. So what has the school considered at this point? Any way of sort of general education of students so that those fears can be overcome, which clearly appears to be the intent of this law, to overcome those obstacles.
So I think I can tell you, so up until the day that Sarah emailed, I hadn't heard of it.
Okay.
I reached out to my superiors through the SU, but no one had heard of it.
Yeah.
Right? I reached out to all of my colleagues throughout the northern part of the state, the directors, none of them had heard of it.
Yeah.
So, right, so this is sort of the first piece of it. So, one easy way is saying yes, like we've slided into the student parent handbook,
Right.
we have conversation,
Right.
but it's even too gray at the moment to even want to do that, right? We have to supposedly have a policy, but I can't see Meg, one of our health teachers, promoting it, right? Because then, you outed your mom of Nathaniel, right? So we'll use him as an example. So
I outed my mom.
Your mom, right? So we'll use him. So he's sitting in Meg's class, right? And she says, "Hey, there's this new you want to know your rights. This new Act 35, blah blah blah, right?" And so Nathaniel decides he's going to call Toby. Right? And he wants an appointment, right?
And knowing Nathaniel, trust me, he would be the kid who would take up the phone. He'd do a little Google research. Right away.
He would call and he would interview many of you. But then how do they get paid?
Right.
Unless I don't know many parents who empower their 13 and 14-year-olds with their own insurance card.
They hold their own Medicaid.
Right? They hold their own or their own private insurance card, right? And so then, so you walk in, you might need to do the intake, and then you're like, okay, so money. And he goes, right? So it's I think for me right now, it's we're in like the -0 stage of trying to learn, figure out what the gray is. So
Then Lisa,
so then we
and-
do empower the
and-
kids, like
yeah.
it's meaningful and it works.
Sarah.
So I think it's a great, so what Rye described is much, so our practice works really heavily in Williamstown schools, and what happens is just that. So there's a referral like, hey, we need you to see this kid, and then it's tag your it. So then the private sector takes over. In where I see, schools that kind of burden to inform, and then some of those limits, because the School Counselor Association's Code of Ethics specifically says school counselors do not diagnose.
Mhm.
So that limits some of the, in order to have a payer model, there has to be a diagnosis of some sort. So that's where that private sector kind of stuff, unless there's a medical diagnosis that you guys could borrow from. And then for us, I see one of the benefits of this law being that in some ways it unfetters us. So when Sandra calls me and says, hey, we need to see this kid, and I say, okay, great, can you handle the paperwork part? And she calls and can walk through in developmentally appropriate ways. So counseling, there's no lag in service time from identified student to counseling. Still certainly some things to work out as far as how do we inform parents and students and things like that. But from the private side, I think there's that piece. And often the very difficult family systems that we work in where these are going to be challenges, the parents like, yeah, do I have to do anything? If I don't have to do anything, great. And so then it can continue.
Yeah, and I think that, there's a lot of issues with it, but I think logistically, so my name is Michelle and I work for the Williamstown School District. I'm the school home coordinator, so I provide social and emotional support available to all students. That's how we treat that. But so what typically happens is the student will with me or another person from student services, yes, please contact my parent, let's get this going. And as part of the referral paperwork, the parents have to sign off giving us permission to speak with the clinician so that we can arrange for them to come in and meet with the student. We can coordinate with them around anything that might be going on at school or schedules. So and oftentimes, like, I'll have access to the insurance information, and if parents are really being slow about getting back to the clinician, then I can pass the information on. My worry would be if a student's saying, I want to pursue seeing this clinician, they make that happen, they reach out to them, but we don't have that specific.
That's a great question, and I wonder if that is contractually handled because so for example, our practice, I do a lot of psychological evals at Williamstown for the purposes of special education determination. I am a contracted school person. So I have our group has a contract with the school, and so Chris and I did that, and so I don't need a release to look at your records. I don't need because I'm a school vendor, so I'm wondering
So are
if
you
that
paid by the school in that?
I am paid directly by the school.
Okay, so you'd be folded into their budget.
Need
to have access to their students' records.
Right, but if it's
They signed just for
but
the
if it's a
testing.
new student, right? Say it's a new student who's.
But they're signing for you, not for me.
Right, but
Yeah,
they're signing
but
for
they're
the
signing for
school
you.
that says the school can do an evaluation.
Yep,
Right,
exactly.
because you're contracted with the school, you're part of the school team,
Correct.
but they have to sign to say they want the evaluation.
Correct. So
Yeah,
so
do
for
the
Michelle's point, that may be part of, and so for school folks, that would certainly be making sure that the counselors that you're working with are people that you would want to contract with, and that they're well vetted. But that may be a workaround for insurance information and access, because I don't have to get additional access rights.
Even though it wouldn't be the school paying for it.
Well, I don't know that for sure. But we could probably ask Sarah Thompson and Chris together.
So I have a couple comments just based on this discussion. The first one is, Lisa, I understand exactly where you're coming from. I think it's extremely unfortunate that schools feel necessary to take that approach. I think that the intent of this bill is thwarted if schools do not incorporate information about this access available to minors without parental consent in their general health education.
No,
I think I can understand why you wouldn't, and I understand why you're saying.
I'm not saying I wouldn't.
Right, but I'm saying, I think
the
it's.
first time we've heard of it,
Right,
we have
no,
to do something
absolutely. I
by
think
law.
it's, yeah, I think it's something, so I would work within your organization, right? I would work within that school organization to make sure, and Robin will talk about this, because he made some inquiries of your organizations, your umbrella organizations, to see where they were with this. So I think it's important that you folks put pressure on them to actually deal with this issue, because I think schools are in, the other point I would make, the observation I would make is it does make me wonder whether in fact the legislature simply just did not think at all of private practitioners, whether they were only thinking of individuals really in the school context, or in the sort of the treatment center context where things are paid.
There's nobody on that
arrangements.
testimony list that is in private practice.
Well, there you
they
go.
are all associated
And so-
with large
And
organizations.
so that's an issue from my perspective. The third thing is, of course, that payment was never mentioned anywhere, as far as I can tell. I think Jessica Olsky in her testimony mentions Medicaid or something. I think she mentions that once, but other than that, I didn't see anything.
She questions payment.
Yeah, but she talks about Medicaid, or being able to, that Medicaid, a kid could access their own Medicaid or something like that, I thought.
If they have their card.
Yeah, I mean, I don't, again, maybe your 9-year-old will do it, but.
You can look it up by social.
But
Well, what was
They're
interesting to me, still gonna then out them when the insurance paperwork goes to the parents.
Well, what's interesting is that you notice one name on that. There was one name from an insurer on that list, which was Sue Kurkowski, who's a lobbyist for MVP Health. And she was on that list. So presumably, I mean, again, I didn't listen to her testimony. Presumably, she actually testified regarding these payment challenges, and whether or not this law would impose an obligation on insurers like Blue Cross Blue Shield and MVP and Cigna and all those to actually, in some way, create an individual insurer-insured relationship with minors for purposes of this particular bill. I don't know what her testimony was. It'd be interesting to listen to it. But I think clearly, again, given that they completely did not focus on private practice at all, or on private billing, it was just tucked under the rug. And maybe, I don't know where Sue came out on that with her testimony. But I think that's another issue that needs to be handled. But I do think schools should go back. You folks should focus your representatives or your umbrella organizations on how do we inform minors of this opportunity, and what ways do we do it in a way that's, that at least provides them with the baseline information, and balance that with the fact that there are a lot of unanswered questions still. And then circling back, of course, to the issue of overarching, does this community want to approach the legislature, approach your representatives, approach your lobbyists to make a change at this point?
Well, I think that's where it would be helpful to have some, I mean, again, like.
Some
Elise is
absolutely
saying,
comparison to the
this
other
is-
states.
it's very new,
Yeah.
but to have some kind of a model policy or whatever.
And
Because there's
Robin's
a
going to
difference
speak to that a
between
little bit this afternoon.
Education and
Yeah.
promotion.
Absolutely.
And that's where I think the slippery slope, as far, again, this is public school. And public schools, we have constituents, and it's about trust and collaboration, and
Absolutely.
and we operate by taxpayer dollars and
Right.
all those kinds of things. So
Right.
there's definitely a political aspect to it and a collaborative aspect. And so
Yeah.
the difference between adding it to your health education that is received by all students
Mhm.
versus individual counselors who are advocates of their students,
Mhm.
and they go through an initial channel of trying to get parental permission, and that is first denied, and they promote for us to seek out therapeutic resources individually.
Yeah.
Whether we provide those resources in our building or not, that gets really slippery.
Yeah, I think you're right, and I think that the bottom line is, I think that, BizBit or other organizations that you folks deal with, and you rely on their resources, right? They have lobbyists, they have general counsel, they have folks who can do the kind of in-depth research regarding the states, the individual states, where the parameters, what experiences those states have had with this, whether they in fact have been problematic, what processes or other pieces to this puzzle they have had to put in place in order to make sure that all of those gray areas are firmed out. And I also think for the model policy, I think you really need to start hammering on them for model policies, for the kind of standardized and vetted documents and processes that you need to protect your minors, to protect yourselves, and to presumably implement the understanding and the intent of the legislative process here.
it makes me think two things, right? The first thing is, right, so if a student comes in and they know about this and they want it, and I refer, I say that, Toby is somebody who I've worked with and think would be good for you, right? Like, Toby and I then can't, like, the kid can go call and make the appointment. No release for him to have any, right? Because the kid doesn't have the ability to release that, right? So that's one. The other part that it makes me think about is oftentimes when parents, like, I think most of us bang pretty hard on parents when they say no, 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 but at a certain point, right, like they've said no 12 times, you stop. I think part of this makes me think about we need to get into the mess more with the parents and figure out what is their fear. It's fear, right? It's fear about what happens at home stays at home. It's fear about the stigma or whatever it is.
Sure.
That we may have to, and it's easier for school personnel, I think, to say this, right? Because we're being paid, right? So our time is taken care of, but I think we may need to get in the mess more with parents and really dig down deep, if they will, in regards to why they don't want this to happen. Versus I can see where a clinician in private practice, you're being paid by your session, right? Like, are you really going to put in 10 hours of pro bono work, right? To have the parents not even give in, right?
Yeah.
But I think, a lot of it is it's also how it's rolled out, right? Within the state, right? It would be nice, right? Like, Vermont is great for local control, but it also is a mess for local control, and that everybody has to do everything individually.
Yeah.
And if there was some sort of, larger, broad rollout, right, then.
And you have bona fide concerns that as it's being rolled out, you might get rolled over, which would not be good. So, but the other thing I would just say is that, again, this is just, I'm a little activist, so this is just me pitching again, but, the Department of Mental Health really should be creating guidance for you folks. I think it's been a real dereliction of their duty they were aware of this legislative process. They testified, at least their commissioner and one of their directors did testify. They asked for it to be put on hold. It was not put on hold. At that moment, which now is almost a year ago now, right? They knew that this was coming down the pipe. They neither really educated you folks about it or informed you, nor did they prepare for what they knew was a January 1st, 2018 implementation date. And they still appear to be sticking their heads in the sand. So even 10 practitioners calling up and asking to speak to the commissioner of the Department of Mental Health and asking them what they're going to do about Act 35 or 32 in terms of in terms of clarifying, the intent of it, the processes, how it's going to be implemented, how to protect from liability, how to deal with payment, any of 5 or 6 list of issues. I think that would be powerful. I think it might get them off the dime, and it might help your organizations in mobilizing state government as well to address the issues. Any final words or thoughts?
One thought that in the private sector, when we work with organizations, we will often create contracts that put into their language shared information sharing. And that is part of our working relationship, that we are two separate organizations, but we are functioning within the same working agreement. So in those situations, it's part of informed consent. So when we work with an individual in those circumstances, they understand that we share information amongst the two organizations. It's part of informed consent straight up. And then it allows us not to have the burden of, oh, wait, I can send someone to you, but you can't tell me if they came. And that mess in the middle is very different. I can see school-wise, the folks that do those contracts may be a little bit concerned about contracting with 12 different private shops to do those kinds of things. So there may be some discussion about how that changes and all the different private folks that come into schools. But information sharing can be worked into contracts, so there's not the burden of a release every time we need to talk about something. So that's a potential as we kind of all go back to create shared contractual language that has information sharing in it, which should not be foreign, because anybody that works with a designated agency, any of the other folks that provide behavioral support services, big agencies are already
into the testimony. There didn't appear to be any consideration actually of that kind of a question. But again, presumably, as I've heard from many of you, it does even if you do that kind of cognitive research and you have that understanding of the development cognitively of an average kid, it is case by case, right? I'm assuming. I mean, but at least you're right. If you had that kind of rigor of research and those analytics to back you up, then perhaps you could choose an age of consent that at least is based on science and data and real life observations rather than just let's throw it wide open. Bruce, did you have something to add too?
I just had a wonder. You showed us the slide of the addendum, the response. I didn't find it in my packet.
Oh,
I'd like to be
the memo from
the memo of understanding.
I can certainly get that to Sarah, and she can
That would be great.
Yeah,
Like,
she can get it to you.
Yeah.
Yeah, you know, the memo really ultimately, from my perspective, says we enacted this law, but it's not almost worth the paper it's printed on because you don't have to do anything. You know, so really the burden is on. So really, again, I really feel like they've almost created a mirage for these kids in a way, right? They created this. They've made themselves feel good, maybe that they've provided, you know, protection or support to these kids, but really have they? If there are so many questions out there and so many concerns and so many gray areas and so many limitations on anyone who's going to take up the sword for these kids, then no one's going to take up the sword. Right. And so you know what? It's not worth it. I mean, it's sad. It's a sad result. Not what was intended, I guarantee. Yeah.
I wonder if you could speak to so age is one of the many protected classes. So as a Medicaid provider, I am bound by my contract to not discriminate based on the protected classes. So in my practice, I treat children as young as 3 all the way up to very mature adults. And if I have an 8-year-old come in and I'm concerned about not having consent, so I choose not to treat them because they are 8, in my mind, that is the very definition of age discrimination, which puts me in violation of this law, but also in violation of my contract. I wonder if you could.
Yeah, I will. And I think Rob will talk a little bit about this this afternoon, but I will address that because I don't think he's going to address that precise question. Age discrimination under Vermont law begins at the age of 18. So age discrimination, an individual protected, to fall into that protected category, you have to be 18 years or older. Age discrimination under federal law is 40. So it's a very interesting gap we have in Vermont versus federal law. And the idea, of course, is that under federal law, the reason this law arose was to protect individuals who were older in the workplace from being fired, who had high salaries from being fired or dismissed, and then hiring younger folks who could be brought into the lower wage pay, right, to come in and replace them. And so that's where the age discriminations, that's the protection that it was intended to create. Now, Vermont, I've actually never done a study of why Vermont's law begins at 18, but I am waiting to represent the 18-year-old who comes in and says, Rose was to protect individuals who were older in the workplace from being fired, who had high salaries from being fired or dismissed, and then hiring younger folks who could be brought into the lower wage pay, right, to come in and replace them. And so that's where the age discriminations, that's the protection that it was intended to create. Now, Vermont, I've actually never done a study of why Vermont's law begins at 18, but I am waiting to represent the 18-year-old who comes in and says, I was as qualified for this job, but they hired a 30-year-old, gosh darn it, I was discriminated against on the basis of my age. I would love to have that case. I think it'd be a hoot. I don't know why they did that one. So in terms of age discrimination laws, they are not implicated in this.
Okay.
Other than, again, the informed consent. I mean, I'm not saying you wouldn't get a minor who might try to sue under this law. I was as qualified for this job, but they hired a 30-year-old, gosh darn it, I was discriminated against on the basis of my age. I would love to have that case. I think it'd be a hoot. I don't know why they did that one. So in terms of age discrimination laws, they are not implicated in this.
Okay.
Other than, again, the informed consent. I mean, I'm not saying you wouldn't get a minor who might try to sue under this law. I will tell you this, the legislature, the law in Vermont is, and courts in Vermont have interpreted the law very narrowly in terms of who has standing, what we call standing, legal standing to sue. And so this particular provision does not explicitly grant any minor standing to sue. Now, again, anybody can sue, and whether somebody would test that proposition, they may. You know, that really informed 9-year-old may file his own brief. But, you know, but again, this law doesn't really technically give them that right of private action. And so, you know, I think that's cold comfort for you because it still could be tested, but that is at least something. It has an authorized private suit.
Is that why it's not so publicized and dormant? Do you think people are just taking that stance?
That might be a possibility. I just think it's not so publicized because Nobody knows, I mean, I just think it's not publicized, I mean, I don't know why, it just, nobody seems to have paid attention to it, there were minimum, I think that the representative from Hartford was able to come home to her constituent and say, hey, I took up the sword for you, we passed the law, great, and then, I don't know
It
what.
was more in the public eye last April and May under its original legislation.
Under the LG, okay,
Yeah,
and that makes sense to me.
That was out, that was in the paper,
Okay,
that was getting paid a little attention to. It seemed,
okay,
the interest seemed to diminish.
once it was opened up to everybody,
I
yeah,
don't know if that's it, but
Yeah.
it was, you could follow it that way.
okay, well, that's interesting. So, any other final thoughts, or I see lunch is being served, so, well, I wish you well. It sounds like, there is a tipping point now of interest in reaching clarity on these issues, so I'm guessing that things will begin to move forward. I think, working through your organizations, working through your lobbyists if you have them, keeping in touch with one another, grassroots, to make sure that you understand, if you can play some role, a minor but important role in this effort, makes sense. Talking to your insurers about it. Maybe you want to have a conversation with Medicaid, maybe you want to have a conversation with MPP or whatever private insurers you take about these issues, and just begin to get the buzz out there. I think that makes sense. So, great. Thank you.
Thank you.
Thank you.
All right, we're just a couple minutes before noon. They're unwrapping lunch. Please eat, take a break. We'll meet back at 1 o'clock and get started with Robin Freeman.
Again, we're gonna end with.
Email students. I am positive that you did. Yeah, but I highlighted it, so I sort of, I'm sure I emailed it to you, because she forwarded it to me, it was from Karen Hunter, and it was a separate email, she forwarded that to me at the beginning of June, like mid-January, so I think I forwarded that right on to you. So you have the original patient's capacity to provide informed consent. I'm like, I have to specialty in our area.
Yeah,
Nobody's
really.
gonna touch that with your goal.
Well, one of the things that I was gonna talk about
So what is the organization?
I was, I actually
Hey, how you
finished
doing?
all my filming. So yesterday, I was working on this stuff all yesterday. And like 10 I missed. I forget at least
When are you starting? You're gonna be working in the summer or something?
Everything's on break.
Okay.
I stayed up and all had a cadence
Okay.
by like 2:45.
I know Sarah talked with.
Right,
talked to
because
me
that
about
organization, yeah.
Now, when you go on,
Do you have days like you're
No,
what was it?
Okay.
Someone picked
You
my
should
30th
mention that
hour.
when-
I was like,
when
oh, okay, I
it's
love
a
you.
little bit.
Yeah,
When I go to school, I'm
absolutely. I would like,
yeah,
but I
Yeah.
take
We'll figure it out.
and I'm
Yeah,
working
okay.
on.
Okay. You understand this kid, and she's
Oh.
surgery, and she's in the office.
Yep.
See, now, Rick's teacher.
Yep, yep.
Yeah, so I know that.
You know, very regularly in her weeks.
Yeah.
Yeah, sure.
Yeah, so, yeah, I would love, there's such a big, on two legs,
Birthday of spring, my husband took a picture of our
yard
yard.
started.
Covered in tables and barbecue, it's still 2 feet of snow, and it's like, so should we drill or mow first? We're like, yeah, no, sir, the first one.
Yeah.
Was it similar to my, you when you were?
I'm amazed at
Remember, yeah, it seemed like you
Eggs,
had to apply like months.
I mean, I'm just.
And then
My
it
dad
just
started
never hit the paper
Yeah.
before you approved.
Yeah.
So,
Sarah,
Setting aside all that.
yep.
It's like saying to someone,
So then I gotta get out my screens. I think I was one of the first ones.
So he was,
because they kept
on
sending
there,
out
so
reminders.
I mean, I was like, congratulations, you won a world tour. You know,
Exactly.
talk about it.
Yeah, so you'll go into the
started,
Yeah, I do counseling this work. Yeah, I'm like a,
So I'm like, I
like a
texted
third
him,
party
like,
contractor.
wow, he's like, no, like,
So like I
sorry,
would be able to.
So, and usually this time it's pretty.
Yeah, I think
safe
so.
to start doing that, but. Just wacky weather. The number of people that I know
I do
south to get away from the snow. They're
But
sending
it's interesting,
Facebook
it's
pictures of their snowy backyard.
Yeah. But it's neat, the first year with her was Michelle.
We worked together, but we never actually got to see.
Oh,
no, that's good. That's
I
fine.
just
wanted
basically the,
challenges so that we're getting different perspectives. And I think my first year, if they have a private,
so I'm connected with her.
what their view on it is.
I thought that was interesting because the more I thought about it, it's like pretty discussion.
And so finally, I said after, you know, what, but it's been let people like know that this kid has, you know,
It's like all of a sudden, sometimes when it's done, everybody realizes that's
Oh,
yeah, like last week she had rushed out.
Yeah, right.
But they don't get to
Some important information.
challenges, so her not being somebody.
I just, like safety. Yeah, sure.
So,
And I'm guessing
but,
she's sure.
now that we're together and that it's constant, you know, it's just
Right.
wow.
Yeah.
I always laugh.
It was my fault. Yeah, fun enough, you know.
Yeah.
But, yeah, so I think teachers like that talkative, just not on
I
top.
don't know, sometimes it's
But I
busy.
think that the difference is that was something
It just all depends on.
exciting and talking about like all the ways you utilize it. So
Yeah,
this
really.
is like
Yeah.
further we go into the more problems there are, and there are no answers except
Yeah.
we need to like,
Kind
oh
of,
yeah,
maybe 100 hours.
yeah, straight things out.
So I will say, just from my experience, after going to Liberty and getting licensed with the state, so in a transcript for whatever reason, it doesn't list how many hours you practice. So when I presented on my education to the state, they said, well, you did your practice and you did your internship, you did a total of 700 hours. But based on the transcript, it was 600 hours. I had to get a special letter, like the practice, because it just said it was 100 hours. So it wasn't a big deal, but it was just kind of extra stuff. Yeah, just extra stuff. Maybe so, yeah.
But then there's actually, yes, you could bill, and that's good information, but then.
Yeah, oh yeah. That was the only.
And then all of a sudden, they're like, oh, yeah. Right. And then all of a sudden, life back gets.
Oh, question.
Oh, well, there's this law.
Yeah, exactly. Retired.
And then there's
This is really hard. Last year, other activities.
You don't see a lot of stuff. You've got license, in the state anyway. So we get a lot of that. We get like,
I don't know if
see us for
I know.
depression or whatever.
I just don't.
well, and I don't know that. Like, she is
That's about it. I mean, it's like a primary commitment. Concern of social abuse.
That's good. I think I still made my parents.
Yeah, that's what she said.
Completely.
So this assignment says, has all these lists of things, probably the
Trying to figure out.
all the stuff I have to know, I have to list, like for mom's requirement for something, how many hours do they have? What's the state requirement? What are the dad?
Yep.
And I'm like, this is what I believe. It wasn't just like.
So if you go, I mean, you can Google, just Google this thing. They've got it on there.
So,
Like the
so
Secretary of
she's
State
really
website.
shy.
Okay.
That's all.
So the Secretary of State website will show
Yeah.
what the substance abuse.
Yeah,
officers
the license, yeah, the license drug and alcohol counselor.
Okay, so that's what I was gonna ask, what are they called?
Sort of, but they were like,
So licensed drug and
And it- Yeah, and it'll all. Yep.
so he's your brother, and his brother was allowed to.
But they, yeah,
Yeah.
I think you just want to be aware,
You know, when you really wanna do this, you have to be
like
there.
the borders to
Yeah.
that.
Yeah.
Because I'm sure you'll get to the.
I mean, it is good to know. Yeah.
So, yeah.
It's always in the back of my head. There are.
Licensed drug and alcohol.
Yeah, absolutely. And I'm not saying, I mean, I think hopefully I was. But that's social.
Yeah.
The kids just come to us.
Oh, no problem.
How do I deal with these dynamics where I cannot say what I want to say? I've heard parents that are checking that out.
Did you tell them I had all the right?
I talked to them a little because I didn't know if I could
but it's really interesting to watch. And I'm like, and so he's in that, and then he's on a Friday Columbia as well. That's nice. He's got really easy, and then Monday, which is really nice.
Well, and I was wondering, because I actually,
Yes, yeah, you can say wherever. I'm gonna start putting these series out of the way.
yes, no, I met you, you can't remember everybody. Well, I was how are you? Yes, I work at like that. I'm excited to hear, she kept saying, and Robin's gonna tell you. That's right. And Robin, so you're the cleanup crew. You get the.
I told you I ordered the crowd for you, Robin.
to talk about here.
They are ready.
I don't think so. I'm gonna go grab the house. Very nice to meet you. I can't wait for you to solve this problem. Right-hand woman of the practice.
The right-hand put on my thing. I had master of none, but then I.
Oh, no, master of all. Master of all.
There's master of none. That was great. I got your puppet show ready to start the puppet show tomorrow. And I don't want to have treatment. You must have treatment. I don't want to have treatment. Yeah, that's how that is. All set up for you. Just like
Sweater, give a sweater, give a sweater you can button up.
Well, I'll take off our socks.
Well, Jim,
He's coming back. He had so
Amanda.
Spouse.
Is one of the owners. Yeah, as well.
So I got my. It's been ridiculous. I put so mine's pretty much cleared out. Like, oh, I don't know.
Sarah, you know Robin. I do. We just shook hands. Yeah.
Oh, that's not my name.
No, it's not. But I think
That's supposed to. They asked Harry, what's the soup? I'm like, I'm like, that's not my favorite. No, that's good. But it's delicious.
It looks delicious.
So he kind of still has the death rattle going on in this.
Oh,
he does.
Mostly better, but the death rattle. So he was gonna go pop into the doctor, get something for the
I can't believe it.
I know.
I know.
It's been bad.
And you two and Chris. Did Chris have it too? Didn't the three of you go down? Luckily, the rest of us didn't. But I had the flu last week. I was in bed for 5 days.
Oh, poor Sarah went.
Had to get better. I had training all last week, and I'm like, I'm gonna get better for my training. So I muscled through, and then we had this week. So
Robin, I should say.
No, we're all healthy now.
now, but no guarantee.
Oh, that's Yay.
Oh, yeah.
So like,
I've done that.
I went to, I did, I invited to have so I did an it was a free conference all about efficiencies, and I was doing a professional development institute about, and so that one I did, ACA in Montreal a couple years ago.
Never did that.
That's amazing. Caroline.
So she'll go to LA. It would be so much fun to get in.
Yeah, we're setting accounts.
Oh, are you?
What's that?
And that process would river. Okay, right. So they don't seem to have a problem.
This one big? Should have done mine first. Should have got mine first.
It's good lunch. Take all the salad stuff off to the side. I told her she'd want enough nap. Look at that. Doesn't that look amazing?
I got the mountain. I got the mountain of food.
It's just fascinating.
You tired?
Yeah.
What you're going to do for groceries since you're here on Friday?
Well, actually, Wednesday, my last two clients canceled, which was so good because I was like, yes, because I actually got to go grocery shopping. It was crazy. And I got to do my laundry. I didn't have any clothes to do.
They all pretend. That's terrible.
I know. I was like, oh, there's drinks over there, Robin.
There, let me move this stuff. This is all our junk.
These guys are super tech savvy.
What?
Well, we do an on-demand version of the course too, so that people who, we've got a couple on-demand people who.
Is this an organization?
No,
You guys find it
ourselves.
funny?
Yep.
It's not, it's not like they should put a rule along. Gosh.
You'd be effective. You'd be effective in all.
Let's talk about that.
But they, we CEUs, and they usually come in, they're usually big national organizations, and I'm sure lawyers have those too.
Oh, yeah.
And honestly, the people, they come in from other places, and it's not always relevant. So
And they don't really know.
They
kind of
don't
your
really know
scene.
what it's like to work in a small community, so they might give an ethics thing, and I was talking to a counselor the other day who said she was at an ethics CEU day workshop, and someone said, my son showed up with his friend, and like, it was my client. I didn't know that my son knew the head, and Eric was coming over. I was like, okay, and they showed up, and the instructor said, well, you should have told me he had to leave right away. And we come and I were like that makes sense in Vermont.
Yeah,
Kids wouldn't be able to have any friends. Or you get a friend because of my occupation. You just sort of go, you're talking about it.
Lisa cracked me up when I was talking about Nathaniel. And she's like, well, since you outed him. I was hysterical. I'm like, yeah, believe me, Nathaniel outs himself on a regular basis. He's a kook. I use Nathaniel, my son, as an example on a few occasions, Robin, to warm the crowd up for you.
It's pretty funny. Well, my kids will say, we live just above Spalding High School, and they'll say, yeah, you see like half my friends. I'm like, I can't talk to you about that. And they're like, I know, that's what I tell everybody. My mom doesn't talk about it.
How are the kids doing?
They're doing awesome.
All those kids of yours?
Yep, they are doing great.
Robin, did you know Sarah has like 81 children?
Wow, that's a lot of kids.
In a nice big house. In a nice old house.
Are you living in a shoe?
Must feel like being raised in a shoe. Actually, you know what? When you spoke at BNI the other day, that was interesting. I did not know that it was like a family farm that you guys used to live. Oh, you don't live there anymore.
We don't live there anymore, but that's what we did for a while, yeah.
So that gave you a little bit of room, I guess.
Yeah,
maybe.
It absolutely does.
So did you sell the farm?
No, my parents owned it, and then they continued to own it. They have a renter there now, but it just became, it was so hard. We lived in Orange, on Route 110. It wasn't terribly far, but we go drop them off in practice, come home, and go back. Oh, we just are amazed how nice it is to live in town.
I know what it is.
Oh, I love it. Do you know where I live? So, do you know if you go up Washington Street, so on the left is Vermont Hill, you're working towards on the right is the State Farm building. Right after the State Farm, there's a blue house, a big blue house. Yeah, that's my house.
Oh, it is.
Fantastic.
So we live in the old Jarvis house. So you know where Otterman and Allen is?
Yeah.
So the next street on the right is West Patterson.
Okay.
Big green 3-story house. That lives right there. That's our house.
Oh, yeah, also we're really neighbors. Yeah, my kids. I mean, the kids walk everywhere. The boys are like, they literally when we have our the kids and the boys are like huge fans of Carolyn Lloyd's. They use gaming. Right, go there every day. Literally every day they will walk there and go there and see what's going on.
My neighborhood street owns it.
No way! I love that. The boys. Yeah, I have to tell you, those guys are such class acts. They are so respectful of kids. Like they treat them as like it just is. It's amazing. It just makes you realize how people treat kids just pretty poorly in general because they are so respectful of them. They treat them right on the level. They know, and they're good customers, my boys. They're like every spare nickel they can wedge out of a bottle drive or something they spend there. I mean, they're like constant. It's hysterical. But oh yeah, the boys have petitioned to work there now for like 2 years, and they're just like, yeah, I don't think so. And then they're just like, work for free, work. Like, but they love him. And then his wife opened that women's store. Yeah, which is
they're who? They're such nice.
Yeah. Does he have kids?
2, boy and a girl.
How old are they?
7 and 9 or 10. I think the boy's younger. And then I was talking to Mike Lannon at BNI yesterday, and I saw him when I was going to work the other day, and I said, "You live on Orange Street?" He's like, "Oh yeah." So we figured out he lives just down the street from me.
Oh, he lives on Orange Street.
He lives on
I
Orange
didn't know
Street.
that. Yeah, that's awesome. I know it's the whole neighborhood. But yeah, wow, I can't believe you live opposite Seth. That's hysterical. No, but the kids they love Espresso Final. They love Harry and Lloyd. And the movie theater, the library. I mean, they walk everywhere in there. Oh, that's Elizabeth. What's her last name?
Oh,
Mike.
Bueno? Elizabeth, is it Rodriguez?
What's her last name? Yeah, Rodriguez.
Yep. She lives on Orange Street too.
She taught with my mom at Casinas before it was first grade.
All this stuff. My cousin is a huge like espresso guy, like fanatic about their coffee. So he's there every day. And so the boys have their own cards. They love going there. I mean, they walk the streets of Barrie. It's like they're like And then Lydia works at Tim Holmes. My daughter, she started there last summer. The boys walk. So the boys, and Tim will say, because Tim lives nearby too. He lives on, I think it's Perry Street, down the street. But so he'll be like, yeah, I see you walking all the time, but they just walk constantly. In fact, there was one insane storm last year, and no living creature was outside except for my boys walking around. They're
the Oliver Twomley's house.
oh my god!
I know. So people will say, oh my gosh, I grew up in this house. And so I don't know Oliver other than I know he likes really nice things because he did an incredible renovation of our house and put in the pool. And
There's a pool, like, there's so few pools.
oh my gosh,
in like
we have
Vermont.
this big pool and a good pool.
Is it an in-ground? It's like,
Really? It was
wow.
a great pool.
Dang,
And the,
you should charge admission. You could make some money off that thing.
the guy that did we did the liner. The woman that bought it from Oliver 8 years ago, and then she was going to turn it into an artist in residence program, and then just kind of lost some steam, and then she decided to study art in South Carolina.
So you just bought it recently?
But a year ago December.
Oh my gosh.
We fell into an incredible deal on it, and the kind of thing you walk
And the
in and you're like,
renovations
yeah, let me write you a check.
Because our house, Tom Lowe's on it. Our house under,
But it's like, I mean, I can always make copies or something, like, they actually.
he redid all the plumbing, all the electricity. I mean, you don't get a house renovated like that. I mean, it's, and then he redid the third floor because we have 4, because I have my stepson is 17, so we have 4 kids.
Help the kids to sort of.
So they all have their own bedrooms on the second floor, which is fantastic because the twins have always had to sleep together before that. They love having their own bedrooms. And then the master bedroom, he redid the area of how they're done. But yeah, it's the same thing. It's like this really nice, big, renovated house. We just, I stood up in Barry Rotary. I literally stood up at it. We made it a master bedroom suite in the
It was
bathroom.
because I was doing.
So I don't have to share with
Valentine's Day.
She don't put anymore.
That's fine. We have our own bathroom too, and I'm like,
It's wonderful. My poor daughter, she's the one because my daughter is the only girl, and she's like, she hates it sharing it with them. I wish I could get her and father done. But yeah, it's the same thing. It's like this really nice, big, renovated house. We just, I stood up in Barry Rotary. I literally stood up in Barry Rotary. Paul and I were getting married the next year. And I stood up in Barry Rotary and said, I need a Barry Rotary. Paul and I were getting married the next year. And I stood up in Barry Rotary and said, I need a house. I need a home. And Tom Babbitt said, Tom Lozon just finished renovating this place, and that's how I got it. Ask and you shall receive. Yeah, Barry Rotary provides for me in many ways.
As well.
Yeah, exactly.
That's great. Well, my son.
I need a house. I need a home. And Tom Babbitt said, Tom Lozon just finished renovating this place, and that's how I got it. Ask and you shall receive. Yeah, Barry Rotary provides for me in many ways.
As well.
Yeah, exactly.
That's great. Well, my son Carson is 14.
Oh.
So he's going to be a freshman. Carson is 14.
Oh.
So he's going to be a freshman. So and he loves video games and come and meet kids. So the boys,
Yeah.
he hasn't eaten kid yet.
The boys are freshmen this year. They're very young for their grade. They're July babies.
Carson a year.
I wish
He's a May baby.
Yeah, I wished Lydia is October, so she's old for her grade. The boys are young for their grade. I wish they had been born the different months, because they could have used another year. And I probably should have. My dad begged me. My dad was a teacher. He begged me to keep them behind, but I just didn't do it. You know how it's hard. You're like, well, that's what it was. Intelligent. I probably should have. You were smarter than I was.
We held Carson a little late, so it was that 5th, 6th grade transition.
Yeah.
We were like, we're just not quite ready. So he stayed back a year in 5th grade.
Jim, this is my colleague Robin Freeman. I don't know if you met Jim.
So smart.
Also having lunch.
I told him. He's feeling a little under That's right. We're just getting you used to this incredible
Bonus
scrutiny.
entertainment.
Well, having just presented to the mental health community here, I know what it feels like to be under the glare of the spotlight there. So just getting Robin used to it before he goes out on the stage.
You were streaming lunch.